Your Honor, as it may please the court, I'm Chris Lombardo here on behalf of the appellant. I'm with co-counsel Zach Lombardo, my son. Your Honor, this appeal comes from an order the trial court entered with regard to a motion for contempt.
Mr. Lombardo, before you get into it, are you going to reserve rebuttal time?
Yes. Thank you. I'd like to reserve 5 minutes. I
Okay.
appreciate that.
Yes, sir. Thank you.
What this essentially is an issue of a parenting plan. We have parties that entered into a parenting plan back in 2018, which was then entered into a supplemental final judgment as well in February 2018. It is a shared parenting responsibility parenting plan. But like many shared parenting plans, we have certain decisions the parties made jointly that were memorialized in that parenting plan. For instance, who pays for the health insurance or the holiday schedules, or how we're going to handle extracurricular activities. We also provided in paragraph 5.8 a provision for how we're going to determine where these children go to school.
And there's no question that the agreement says that the former wife's residence will determine the school zone.
Correct.
The question really in this case is, does that mean she controls where the children go to school? Because as we know, in this case, she endeavored to move to Collier County and wanted to put the children in school in Collier County in the zone of her new residence, right?
Correct. Well, initially what she wanted to do was put them into a private school in Collier.
Right.
And then later, and so
and she was told no.
Right.
Told no by the court. She couldn't do that.
Well, what she was told was, we're going to maintain the status quo until we can hear the former husband's supplemental petition for modification. And she was given the opportunity to file a counter supplemental petition. And ultimately, we did try the supplemental petition, which the former husband lost. And part of the issue here is there's no geographic restriction beyond 6113001, the 50-mile radius. So given the 50-mile radius, the mother could have moved to DeSoto County, Sarasota County, Hendry County, Glades County, Charlotte County, Collier County, and within the Lee County District. Had they wanted something tighter than that, they could have negotiated that. Had they wanted a provision that it would be the Cape Coral charter schools, they could have put that in the parenting plan. It is not. And so what we have is a parenting plan that says we've made the decision that mom's address controls the schools and the school district choice. So she moved within 50 miles. That's undisputed. She's in North Naples within the 50. In fact, she's within 40 miles. And what we have is a circumstance where the trial court ultimately looked at the supplemental petition for modification, which was amended, by the way, after the original hearing from the magistrate with regard to the August of 2019 order. In February of 2020, the former husband and the father amends his supplemental petition, and he asks for increased time sharing, modify child support, modify the decision-making authority, give him ultimate decision authority, modify the parenting plan to restrict the children to Cape Coral charter schools, modify the school designation to his address, and then add a relocation restriction.
So the agreement itself then doesn't really provide for shared parenting responsibility?
Oh, no, it does provide for shared.
Well, if it does, then shouldn't there have been a shared decision on the change of schools?
Well, there actually was, because in the parenting plan itself, the parties made the decision that mom's address is the controlling address. Now, I would agree that if she said, I want private school or homeschooling or virtual schooling, that is a decision that was not made and needed to be addressed. But if they wanted something more restrictive, and look, what you'll see is when we try the case.
Well, if I'm a textualist, I read that argument to say that that provision says that the zone at the time the contract was entered is where the children go to school.
Well, that's not how I read it.
Again, if I'm a pure textualist, that's how it would be read, right?
Well, I'm not so sure I agree with that. If you're a pure textualist, what it says is mom's address shall be used for school designation. It does not say, and this is the school, which it could have. They could have provided for all of that. They didn't. And when you look at the cases that the court relied on at the time of the trial, and in particular, Hutchinson and Regal, both of them shared parental responsibility circumstances. So both of them, we have the same approach. And both of them, the court concluded that within the 50-mile radius, because there was no greater
Well,
geographic restriction.
I
in those
understand your
cases.
argument, but isn't that all kind of moot once you have the general magistrate make a report and recommendation that the mother doesn't object to the findings of fact, doesn't file for rehearing? Didn't the magistrate resolve all of these issues?
No, he did not. What he did, was he entered an order of enforcement for purposes. It was a request filed simultaneously with supplemental petition. It was a request for a temporary injunction to maintain the status quo. What the court said was granted. And then the court gave her the opportunity to file a counter petition. And then the court actually tried the case subsequently, which is how you wind up with the ultimate decision in this case, which finds that the former husband did not meet his obligation. And when you look at that, and what you realize is the court did not amend its parenting plan. The parenting plan, as we sit here
Well,
today,
you're begging the question that it needed to be amended. The argument, I think the magistrate said it's clear, it's evident, and Judge Carlin said she's in contempt. She violated the court order. She took the kids unilaterally out of school. That was never part of the program here. You're saying, oh, her address controls over everything else, and the judge didn't buy that.
No, that's
that argument.
That's not exactly what I'm saying. What I'm
Okay.
saying is these parties made a decision that her address controls school designation. I would agree that when it comes to private school or other types of school or education, that does not control.
Why?
But
Why
you
just
can't-
that? Why do you limit your argument to that point? Why do you
Well,
tie your hands? Why isn't it good for everything?
Because obviously if there is a switch to say homeschooling, that to me is a different issue.
Okay, but you're being the judge and jury of that issue. That's why we have you have agreements, and the judge is the ultimate decider.
Well,
And he
actually,
adopted the magistrate's report.
well, so the way I see this is these parents are the ultimate deciders, and they've made their decision in that parenting plan. And what the court, when you look at the final order of the court, what you have is a restriction requiring the children to go to Cape Coral charter schools, which is nowhere in the parenting plan. It prohibits Cape Coral from unenrolling them, nowhere in the parenting plan. It prohibits the district school board of Collier County from enrolling them. Mind you, there are six other counties within the 50-mile zone. And so ultimately, when you look at the supplemental petition, the amended supplemental petition that the former husband filed, where the former husband asked for all that relief and it's denied. And the court essentially has said the parenting plan stands as it exists. So you cannot hold her first in contempt because there's not a clear statement, and certainly it isn't deliberate or willful when the court says the parenting plan stands. There was in the final order, there was no provision that saved or incorporated the prior order, which we believe was a temporary order. I mean, that order was done in anticipation of further judicial effort to resolve that issue. We tried the case, they lost. She won. She had the right to move. She still has the right to move within that 50-mile radius. And they made the decision that when it comes to school, it is based upon her address. And so this idea that now somehow we wind up with this much more restrictive provision, which cannot be done on a motion. I mean, we tried the supplemental petition, they lost. And then they filed a motion, and now we have a parenting plan, presumably, that's been amended by a motion that limits the children to Cape Coral schools. Had she moved within Lee County, she could have done that. It would have been a change. There's nothing that would require it.
You're going really fast. Isn't the parenting plan required? Didn't the parenting plan require the parents to confer on all decisions regarding the children's best interests, including education? Isn't that in 2.3, parents to
It's
confer?
the standard language for shared parenting, and you're right, yes. But just like other aspects, for instance, health insurance, the parties made that decision and reduced it to writing so the court would be clear with regard to school and school district choices, it would be mother's address. So otherwise, what you're doing is saying those words
Back in 2018.
Correct, and that's never been amended. And there was a specific request by the father in his amended supplemental petition to modify that and provide that it would be his address. That was denied.
Well,
So
obviously, Well, the problem is it's reactive to an interpretation that nobody saw coming. And the judge didn't agree that she had the right to do what you say she had the clear right to do. I understand what you're saying. She got in there, my address. If I move, it's still my address. And I don't think the husband bought that. He said, hey, the parenting plan trumps her physical address.
Well, and see, the parenting plan does provide for the school designation. I mean, that's the point. And so, and it has to be in there, and they have to make that decision, and they made that decision. And so the court can't come back later and say, I interpret a designation of mom's address as not really being mom's address, because that's what's happening here.
Well,
When
I
the
don't
court-
want to bog you down with the same question, but if you have some other points, you can move on. I didn't mean to.
No, that's
That's
okay.
nice.
That is the primary issue here. I mean, I
Okay.
get this. And the point is, when you look at, for instance, what the trial court did at the trial, is the trial court concluded they did not meet their the standard of a substantial change in circumstances, and in fact quoted Hutchinson and the Regal case, which is a move of less than 50 miles, including a change in schools, does not constitute a substantial change in circumstances. When you have a parenting plan that says mother's address or father's address, for that matter, is the address we're going to use, and it hasn't been changed, then that's what controls. Now, there may be other variations on the theme that may require additional input, and I agree, because not every decision was made. But when it comes to public schools, the address of mom was the controlling address. And so when you get to the point where you look at this and say, okay, so what did the court do? The court maintained the status quo until we had time to try it. And in fact, the father recognized that, because the father, after the court entered that order, amended his supplemental petition to add the additional relief. We tried that case, and the court decided that they did not meet their burden. So the parenting plan stands as written, which is mom's address. And that's important, because when it comes to, and particularly the language the court used, the court stated and relied upon the fact that the mere moving of less than 50 miles coupled with a change in school is not sufficient. And so when you take that and interpret that, the ruling of the court at the end of the trial that's in writing, from mom's perspective, the parenting plan doesn't change. The move was not a substantial change in circumstances. The change in school was not a substantial change in circumstances. So things remain the same. She has the right to move. So you cannot possibly hold her in contempt when that order did not incorporate the prior order. That prior order is of no longer of any force and effect. That order was there to maintain the status quo until the case could be tried. We tried it, and the court concluded that they did not meet their burden. And so this is not a circumstance where one provision usurps the other. No, quite the contrary. It is a memorialization of a decision, no different than mom gets Christmas Eve on odd numbered years. That's a memorialization of a parenting decision they made jointly. They put it in writing, and it's there. And so that's what you have in this circumstance, is when it comes to school choice purposes, it's there. And so when you look at what the court ultimately did in its final order on the contempt, the court went way beyond what it could do, because we're now looking at a motion, not a petition. The court's already ruled that the supplemental petition failed. And then the court, despite what the court ruled with regard to the supplemental petition, turns right around in a motion for contempt and then provides the relief that was requested in the supplemental petition. And so, quite frankly, you can't do both. You can't say that the supplemental petition requests don't meet the standard and are not a substantial change in circumstances which would warrant a modification of the parenting plan, and then turn around on a motion for contempt and say, but we're going to amend the parenting plan. Because nowhere in the parenting plan does it say that these children are going to go to Cape Coral charter schools. It doesn't say it. Nowhere does it provide that the Cape Coral School District can't unenroll the children, or that the Collier School District can't enroll them. So you cannot take in a motion and do an amendment to the parenting plan. That's absolutely unequivocally the law in the state of Florida. Nor can you take a circumstance where you have now an amendment and then hold a person in contempt for what you've just amended. And so the prior interpretation, which literally just says granted, and you have to look then at the prayer for relief. And what was the prayer for relief? The prayer for relief was maintain the status quo. Why was it maintain the status quo? Because simultaneously they filed a supplemental petition for modification, which they subsequently amended. That's what we tried. And so when we get to the end of this, that parenting plan, even as we sit here right now, still says the exact same thing, that
Mr.
moms.
Lombardo,
and
just so you know, you're under rebuttal time, but it's your time. You can use it any way you
Oh,
want.
well, so from our perspective, this is a circumstance where this court needs to recognize that the trial court went way beyond its jurisdiction in amending a parenting plan on a motion, and it needs to be reversed. And we don't see this as a circumstance where the one is trumping the other. What we see is a written, just like in Regal, just like in Hutchinson, a written presentation of a parenting decision. And I thank you for your time.
Okay, you'll have 4.5 minutes when you return. Mr. Fink?
May it please the court, Your Honor. Your Honors, Mike Fink on behalf of Scott Carl Boilard. The August 27th, 2019 final order determined the issues that are raised today. Having said that, I want to tell the court how important this matter is. It's of great importance to the families of Florida, because Chapter 61, Section 61.13 2B3B requires in the parenting plan that they put in an address to be used for school boundary determination and registration. However, there is no framework or structure to determine which parent that would be. And what happens throughout Florida on a daily basis is these families are in mediation. They go, oh, and we need to put this, we need to designate who's going to be the designation for school boundary and determination registration. And the folks will say, oh, it's just for school bus or this sort of thing. And it's taken somewhat for granted, but it's essentially an arbitrary type of provision that has to be in there. And with all due respect, and Mr. Lombardo was not in the case and was not the lawyer who did not appeal the August 27, 2019 final order. But nonetheless, the appellant's position today, quite frankly, is inconsistent with the best interests of minor children, and certainly the principles of shared parenting, to the extent that, as far as we are concerned, on behalf of the father, and we think that, and on behalf of the minor children in Florida, that shared parenting is primary, and that to allow and permit this provision that is required to be placed in each parenting plan to essentially create a super parent who can move anywhere at any time, as many times as they want, less than 50 miles, take the kids out, put them in a new school over and over again. I mean, technically, that's what they're saying, without any input or review from the court or input.
Mr. Fink, the problem is that's the way the agreement seems to read. That's the tough part about it.
That is absolutely the tough part about it. There's no cases on point.
Point blank that the children's school will be determined by the mother's address. And it doesn't say that if she's going to move, she's got to consult with the husband. It doesn't say any of those things.
Absolutely. That's why it's so important, because we've not been able to find any case.
But you're asking us to read language into this contract.
I'm asking the court find that the principles of shared parenting are omnipotent, that they are going to be involved in all significant decisions related to the minor children, no matter what the provisions say, at least in my opinion. And I know that our position is they don't get there, and you don't have, this should be a PCA, but if you're going to write anything, you should write something that supports and helps provide fundamental stability to the shared parenting principles, and that does not essentially set up what could be, and essentially in this case was a trap door.
Well, I think
Many
that
other-
unfortunately, if we were to write, we would probably say that the lawyer should have included this language in this agreement to make it clear. I mean, it's unfortunate, but the agreement reads the way it reads. You know, that's the tough part about this. There should have been more language to
Right,
explain it.
absolutely. In any case I've handled since, I've made sure that I've placed something in there to override, to do what the law should be, what I believe the law is, frankly, by saying this provision is not going to determine, dispositive. It's simply technical reasons, not to determine what school they go to.
Well, tell me about the special magistrate. Was there an evidentiary hearing?
There was, Your Honor. The court initially, as we indicated, entered the order August 27, 2019, resolved, as far as we are concerned, all the issues, and I don't frankly appreciate any real argument that would change the fact that that was a final order. Mr. Lombardo wasn't there. Nobody said this is, holding on, or that there was more to happen, other than I certainly wanted to make sure when I filed the supplemental petition that if there was going to be more concern about it, I'd rather change things to my client's benefit. It had nothing to do with the fact that that was an order that was appealable at the time, and it was waived and nobody appealed it. Again, it wasn't Mr. Lombardo's decision to make, and he wasn't involved in the case, but he also wasn't involved to be able to say what the appellant was told or not told and what things meant. The bottom line is, based on, we think it's clear under the Charles v. Williams case that this particular appeal by the contemptor trying to attack the underlying order is inappropriate and not permitted. So we don't see a technical appeal here because it was previously determined. This is the court previously made the same decision that it made a year or so before, that they did not appeal. So I do not believe there's any legal basis for the court to address their appeal. And while they've made some, they said that the appellee has attempted to classify the prior motion as a motion to enforce. That's a decision that was made by the magistrate at the time. And again, they decided not to appeal it, or at least an appeal did not take place. And so they are stuck with how the court, within its discretion, treated the father's motion related to the mother's attempt to unilaterally move the children out of schools and out of the schools they've been going to, and the school district they've been going to their whole lives. That classification is likewise, we believe, unassailable and not something that can be readdressed as a matter of law. We believe that the motion to enforce was proper, the contempt was proper. She was aware of the type of conduct and what would be violative of the order because of the August 27, 2019 order in the first place. So that when she did the same thing, she should reasonably expect that there would be contempt proceedings, and she can't basically say that she had.
Well, did she not ask the father to approve her decision to move and change the school for the children before she did? And he said, no, I don't agree to that.
No, she made the decision before she approached the father. In fact,
And then he
filled out all the
found out. And
right, fill out all the applications and didn't put him on there, or
She didn't consult him at all.
apologize. I didn't-
He wasn't consulted ahead of time.
No, Your Honor,
So in other words, beg forgiveness after the fact is what happened in this
that's
case.
correct.
Okay. Thank you.
So, we believe that the court should uphold the trial court's decision. The August 27th, 2019 order is dispositive. It was a final order. They did not appeal. We do believe that the issues presented are extremely important, that the shared parenting, the principles related to it, and really the legislature's focus and the history would suggest and certainly support how important it is for parents to cooperate and make major decisions, even in the light of 61.13 subsection 2B, 3B, which requires an address of one of the parents be designated as a boundary and determination for school and registration purposes. Again, if they were to disagree about it, and that's why it's like the last thing that is decided, what would be the structure? The statute doesn't provide any, legislature doesn't provide any guidance as to how that would be litigated. That would be a stumbling block to every parenting plan, and is now more than it ever has been, and there's no case directly on point. Thank you, Judge.
Thank you, sir. Mr. Lombardo, you have 4.5 minutes, sir.
Thank you, Your Honor. First, the August 27, 2019 order is clearly not a final order. It anticipates additional judicial effort, in fact, directs that. It grants, and you have to look at the prayer for relief, it grants a request to maintain the status quo until the trial. Who asked for the trial? The father asked for the trial. He filed a supplemental petition, an amended supplemental petition, and asked for this relief. That what is happening here is a confusion about shared parental responsibility. The reality is we have shared parental responsibility, but the parties have made certain decisions. For instance, holiday schedules. We would not say today that we have to come back and now come to a consensus again each holiday over who gets which holiday. No, they made the decision in writing. They could have, and the truth is, when we all recognize the rules, 61.13.001 provides 50-mile radius. They could have asked for less. They could have provided for a specific school. The request is for an address under the statute. That's not what they did. They said they went beyond. They said, no, we're going to use mom's address no matter what. Mom's address, mom's residence for purposes of school choice and school district. So the decision was made. What's important to recognize is on August 20th, 2020, the trial court entered an order that through the special magistrate after a full trial, and it said, based on the case law, neither the increased driving time or the change of schools meets the necessary criteria to establish the first prong of the modification test. The initial prong has not been met, the petition is denied.
Would it have made a difference if the word current was inserted before mom's address?
It would have. Words have meaning. You could have said current address. You could have said this address. They could have said Cape Coral Charter Schools. And Judge, you're correct. The reality is, as a practitioner, here's what we go through when we negotiate these. We talk about the issues. What's important? Is it important to you that these children are in a particular school district or in a particular charter school or a series of charter schools? Well, then you put it in the agreement because you don't want to wind up where we are right now. What we have is a circumstance where they made a decision, and what really the appellee is asking is for you to create confusion. We have a lot of case law that basically says what I've just said, which is just the move and a change of school is not sufficient. If you want something more than that, you either negotiate it up front, and lawyers beware, that's what you need to do, or you file a supplemental petition, and you better have enough to meet the first prong, which is a substantial change in circumstances. You have to ask yourself this: if the August 2019 order was final and resolved all the issues, as Mr. Fink has suggested, how in the world and why in the world did we have a trial on their supplemental petition? And why do we have a circumstance where the court says it's denied? And if you look at their amended supplemental petition, here's what you see: a request for all of that relief that the court then put in the 2021 order under a motion. That was denied. The reality is we have stability. We may have to warn our practitioners that you need to be aware of this. I mean, I have done this for 40 years, and I have done this in a variety of ways. We get it, it's a 50-mile. You can say Lee County schools only. You could say Cape Coral schools only. I mean, if that's what the parties decide, that's what they decide. If they decide dad's address, then sorry, mom, it's dad's address. And you may not always like that. And unless he crosses the 50-mile mark, you're not going to have a say. You gave up that right. You had counsel, you entered a written agreement, you did what you made the decision. You cannot now ask a trial court to add language to the agreement, which is exactly what's being requested. We want particular schools. We want a geographic location. We want to restrict school districts from enrolling and unenrolling, who aren't even a party. And we want to hold a party in contempt when the court said the parenting plan stands as it is. So you can't get there. What the trial court did was a mistake. It was an error, and it needs to be reversed. This is not a situation where we're asking for a super parent, nor are we suggesting that somehow we're going to create instability. No, quite the contrary. Here is the
Mr.
warning.
Lombardo, you're out of time, sir.
Let me finish with this. The warning is this: the words have meaning. Negotiate your parenting plans carefully and recognize that courts cannot add language to the plan. Thank you.
Thank you both. This, of course, is a very tough issue in family law, and it's painful to watch children have to be victimized by these types of things, but it is what it is, and your briefs and your arguments are very helpful to us in understanding the issue, and I thank you for that. Okay.
Thank you, Your Honor. Thank
Have
you
a
for
good
doing this
day.
by Zoom.
This concludes our morning docket. We will retire to consider these cases. Thank you very much.
Good day.
Thank you.